क्योंकि
Yeah. Can you just let me know if my screen is visible or not?
Yes, ma'am, your screen is visible.
Okay, fine, great. Okay. Very good evening to everyone present over here. My name is Muskan Talokani, and today we are going to have a session regarding mood court. I will be giving you a brief overview regarding the same. So, without wasting any more time, let us just start with the same. Okay. Firstly, what is a mood court? That's a very big question. Is anybody over here having any sort of idea or any view regarding the same?
Ma'am, like in my view, like it's an artificial kind of a code which we set up to give law students a vague idea, like how the code works.
Exactly, right. You pointed out very rightly that moot court is nothing but a replica of the original court. If I term it in in very simple terms out there. So moot court is the nothing but the in reality how we basically are there in the court, the way we behave, the way we present our cases, the way we solve the issue out there. It is same the exact replica of it, just like a miniature. So it is nothing but it is an artificially created arrangement wherein we can get a very clear and good idea, a real idea how a real code basically works, right? So just there is a small difference out there. In a real code, we have the real cases out there. In a moot code, we have a hypothetical cases which have been framed, nothing else. So, but yeah, definitely there is one thing. Whatsoever the hypothetical cases are, they are inspired from the real actual cases only, just with a certain sort of modifications out there over there, right? So that is what a moot court is. But now the question arises is why is moot court important for a law student? In
Ma'am, sorry for the interruption. Ma'am,
Mhm.
are we going to get these notes also?
Akshay, can you just look into the same once if possible? Hello, Akshay, am I audible to you? Just, just a sec. Hello, Akshay, am I audible? Okay, fine. Uh, okay. May I know who has asked this question out over here?
Yeah, ma'am, I am Smita at this side.
Okay.
Yeah.
Yeah. Smita ji, actually, the regarding notes, I guess Akshay would be able to brief you out in a more better manner regarding the same.
Okay.
Yeah.
Okay.
Yeah. So regarding the same query, I will basically address for the same in the end. So that's fine.
Fine.
Yeah. Okay.
Fine.
Thank you.
So I think we need to connect with Akshay regarding the notes part.
Yeah. Yeah. Yeah.
Okay. Anyways, ma'am, one more thing. Can we directly be after this course or something? Can we directly, if we have any query or something, can we contact you directly by some
Yeah.
way?
Definitely. 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 Yeah.
Okay.
Yeah.
Okay.
If there will be anything such, I will definitely share my contact details with you guys, so you can
Okay.
ask me out anytime. That's absolutely fine.
Fine. Thanks.
Yeah.
Thanks a lot.
Thank you. Okay, so moving ahead, regarding the importance of moot court in our entire law school journey, one of the most important things which we would come across very frequently is regarding moot court. And of course, college ke baad kabhi you would be getting that pressure, yeah, you should take part in moot court and all. But what the big question is, why should we take part? Why is moot court very much important, right? So there are actually many different reasons out there. Before moving ahead, there is just a small request to everyone. If anything noisy comes in, kindly keep it on mute to avoid any sort of disturbance. Okay, thank you. Okay, so regarding the importance which we were discussing, so there are multiple reasons why a moot court is important. Starting with the very first is collaboration. See, the thing is, whenever we are involved into mooting and all, we are able to socialize, we are able to connect with a larger audience, not only from a particular nation, but across the globe, right? Students from various different law schools, institutions, they come together, they are representing themselves. So it gives you a very good and immense opportunity wherein you can gain exposure also to the outside world and you are able to connect. And the field in which we are, law, it's all about connections. The more you build up connections, the more it is gonna definitely gonna help you out. So connections, collaborations, networking, that is one of the thing. Another thing is writing and researching skills. Whenever you take part in a moot court, it is definitely gonna help you improve your research abilities. Why so I'm saying is that because at that time, whenever you're gonna present your oral arguments in front of the bench, on what basis are you gonna present the oral arguments? You're definitely gonna present it on the basis of the research which you have done previously, right? So whatever you research, whatever case laws you find out, whatever arguments you frame, right? According to that, the entire thing is being presented in the oral rounds ahead. So the more the better the research, the more better you can do it ahead, right? So it's everything about researching only that how good you are basically researching. So it will definitely gonna improvise your research skills and plus how it is gonna improvise your writing skills. Let me tell you out there, whenever we are basically presenting ourselves in a moot court, we need to present a memorial out there, right? So while presenting the memorial, the content which you would be writing on the basis of your research, that is basically gonna help you improve your writing skills out there, right? Up, you have improved your writing skills, you have done research, you have made a very excellent memorial out there, right? But at the time when you start your oral rounds, at the time when you present your arguments, wherein you defend or wherein you support your client according to the situation out there, right? It basically will help you to gain your confidence. Why? Because when you would be presenting it, you would be presenting your point of view towards the others. You would be having a conversation. And the more you converse, the more you talk, the more you present your viewpoint, it is gonna definitely help you develop your confidence towards that point. And you are definitely not gonna be afraid anymore to question anyone or to speak to anyone, to speak in front of any other person, right? So the more you do mooting, the more you would be building your self confidence out over there, right? Because oral arguments presentation helps you build your confidence level. So if you are doing it, it is definitely going to help you build your confidence and you won't be afraid anymore in your future life ever. Moreover, if we see it is not only this, but excuse me. Yeah. Moreover to that, if we see practical experience you would be getting, right? So of course, law schools you are going to and you are getting all the theoretical knowledge out over there. वो मैं सब सिखा देते हैं, राइट? ये सेक्शन में ये लिखा है, ये केस में ऐसा हुआ था, वो हुआ था, ये हुआ था, राइट? Theoretically, you know each and everything, right? But when it comes to practical life, when it comes to real life, that is altogether a different thing. Because theoretical wise, but like in how to apply that theory to real life situation, that moot court is definitely going to help you out with that, right? Secondly, whenever we are doing a moot court, it is not an individual person doing. There is a team working behind it. There is a team of three people, a petitioner, a respondent, and a researcher. Three of them together work and they combine efforts helps in a successful moot court, right? So this will definitely gonna help you out how to work in a team, how to manage, how to cooperate, how to understand, how to successfully examine the strengths and weaknesses, and how you can efficiently work together. How you could basically work with a huge public out there, how you could work with different people, how you can collaborate with them, right? So this is the reason why moot court is important, because it is giving you a lot of advantage. And there are a lot of benefits of the moot court also. As I right now mentioned, that it helps you in team building. It will help you in time management. It will, whenever you are going to do a moot court, of course, while having a practical exposure, you would be having more clarity regarding the concepts, regarding the laws. And the more you do the mooting, the more you would be able to, improvise while reading the judgments, the more quicker you would be able to read the judgments by time. Of course, initially this definitely going to take a time for you to understand and the terminology and judgments and all. But the more you do mooting, the more research you do, and more your reading ability is basically speedified. And it will basically not only that, it will also help you to basically learn about new laws, maybe which you haven't basically learned in your law school. You will get to know about what are the different sort of laws acts prevailing out there. You would be not only that, uh, it will help you in creating your mindset in a very innovative way. It will develop your innovative thinking, because how you present your arguments, that requires a lot of innovativeness, a lot of newness. So your thinking, your ability of thinking would definitely gonna be developed a lot, right? So these are few of the benefits and of the mood put out over here. Now the bigger question is how a mood put is to be done. See, there are different steps involved in a mood put. Uh, the very first and the most important step of all is to read. Read the problem. The thing is, there's a kind request to everyone. Kindly, can you please mute your mics if possible? Okay. Thank you. Okay. So the most important part of it is read. Law field is all about reading. The more you read, the more it will be beneficial for you. The very first step is whenever you are getting a issue, whenever you are getting the mood problem, read the problem twice, thrice, read it. And whatever the facts are there which are important to you, highlight them. Highlight the important facts. And of course, there is a timeline of facts. There is an incident. One incident would happen, after that, other incident would happen. Make a timeline of that. Make a timeline of facts. See what first happened, what happened secondly, then what happened thirdly. Make a timeline of it. And before starting the advanced research, it is better if you have a basic Google search. Like if there is some sort of a section given which you aren't aware about, what that section is all about. Just do a basic Google search about what this section is, just to have a general understanding, right? So reading is the most important part. And after doing that, try to summarize all of your arguments. Sorry, my bad. Try to summarize all of your facts in a very small, brief manner in 5 points, if possible. So it will help you out in future while doing the advanced research. After reading the problem, after understanding your problem in a very thorough manner, and when you are very much well aware about and it was about your all the facts, now the time comes when you start your advanced research. Now the bigger question is, okay, we need to do advanced research, but how can we do it? From where do we get the information, right? So there are multiple different sources through which you can basically do the research. We are having SEC, we are having Manupatra. There's certain handles wherein you would be able to do your research, wherein you can find different case laws, Supreme Court judgments, High Court judgments, and other lower court judgments too, right? So these are few. We even do have Indian Kanun. We are having multiple different sources through which you can basically do the research. Now, while doing the research, what we are supposed to do is we are basically trying to apply the law to our facts. We are going to try to apply the law to our facts. And we are basically, at times the thing is the issues are already present in your mood problem, right? So we would be trying to apply the law to the facts and try to solve the issues. But if it, in case it happens that issues are not there in your mood problem, there is a discretion given to you that you can frame your own issues too. So to frame your own issues, it is very much necessary that you read the entire judgment. You need to read the entire fact sheet and you need to basically frame your own issues, right? And while doing a research, there is a small tip. Just don't go with the summary. It's very important that you read the entire judgment which is given to you. Because whenever you would be reading the judgment, you would be definitely gonna know not only about the facts, you would be getting to know about the arguments which were presented by the petitioner and the respondent at that time while fighting the case. You would be able to know the judgment, what the court said. You would be able to know what were the cases which were referred earlier. So you would be getting a lot of things out there. So it's a small tip. Never just go with the summary. Always read the entire judgment whenever you're doing a research, right? So these are certain basically steps which are involved in the mooting process, right? So that is one thing. Now, why are we doing research, right? We are doing research to make our memorials, to present our oral arguments, right? So now there is a question out there, ki, how to make a memorial? What is a memorial, right? Is anybody having an idea regarding the same?
A written draft we are supposed to submit to the judge.
Yeah, exactly. You stated that out very rightly. That memorial is nothing but it is a written draft. Written draft of what? Written draft of the arguments which we are going to present, right? On the basis of which you would be basically fighting the case ahead in front of the bench, right? So memorial is that itself, but of course you can't present your memorial in a very abrupt way. There is a specific manner, there is a specific way in which you need to basically present your memorial. Memorial basically considers of different sort of elements out there. I would like to even show you a memorial which I'm having right now after this presentation within few minutes. So you would be having a clear idea and more better idea how to frame a memorial, right? So basically, whenever you would be framing a memorial, you would be having a cover page. Then you would be having table of contents, index of authorities, list of abbreviations, statement of jurisdiction, statement of facts, statement of issues, summary of arguments, arguments advanced, and a prayer, right? I will like to share a memorial with you. Just let me know if my screen is visible out there. Just a second. Is my screen visible? The memorial is visible. Is the blue color one visible?
Yes, ma'am.
Yeah, okay, definitely. Yeah. So I guess you would be able to see the memorial over here. This is a memorial from the side of the petitioner. Okay. So there are certain rules actually while making the memorial, that whenever you would be making a memorial, the front page, if you are from the side of petitioner, it has to be in blue color, and if you are side from the respondent, it has to be in red color. So that's a rule. So this is a memorial from the side of a petitioner, and you would be able to see that on the very front page. You could see basically the code number, the name of the competition. You would be able to see the name of the forum that is before the Honorable High Court of Bombay. You would be even able to see the uh, original application number. You would be at times able to see. You would be able to see the name of the parties. Over here, the parties are the petitioner is Julia Rawat and the respondent is State of Bombay, right? And you would be even able to see that at the end, it is basically even written that the memorial is basically framed on the behalf of petitioner. You could see the written submission on behalf of the petitioner, right? So this is how the front page of the memorial looks like. Then if we move ahead, you would be able to see the table of contents. Table of contents in the sense of index, right? It's like an index wherein you mention regarding whatsoever the elements you have used in the memorial, and you just state out the page numbers of the same, right? So it's similar to an index of your entire memorial. And then comes is the index of authorities, right? So index of authorities is nothing. In index of authorities, you are basically gonna mention about all the statutes, all the books, or any international reports, or any law or anything which you have basically used. Basically, it's nothing but like a bibliography, the sources, right? So whatsoever your sources are, you're going to mention about the same, right? Whether it is a book, whether any of the article you have mentioned, any website you have mentioned, any statute, any law, you're going to mention about that. You're going to cite all the authorities, and just try to do one thing. Try to always mention them in an alphabetical order if possible, right? So index of authority is nothing but the sources from where you have basically done your research, and all the statutes and books which you have utilized for your research. Then comes is
Ma'am, can
uh,
you go back to the table of contents, please?
yeah, sure,
Thank you, ma'am.
yeah. Were you having any sort of query out there over here?
Can you repeat what topic should be included in the table of contents?
Yeah, definitely. See,
I
table
mean,
of contents is nothing, but it is like similar to an index. Okay. So,
okay.
like if there is a textbook, how is the index? It is mentioning all the name of the chapter and the page numbers, right? So it is
Yes.
similar to that only. Ki by whatsoever you are mentioning in your memorial, you are gonna state that and its page number.
Okay. Thank you, ma'am.
Yeah, yeah, welcome. So that is basically table of contents, and then we had the index of authorities, wherein we mention all the statutes and the sources, basically the books or any other sort of document, anything which we have referred to. It may even be international reports, any human rights commission report, or any report. You can even mention about the same. Then we even definitely we are gonna mention regarding the cases. Okay, so whatsoever cases you are gonna mention about in your memorial, you're gonna basically write the name of the case, and you're also gonna write the citation of the same. Citation, okay, citation you can get from the judgment. You need to find the entire judgment. In that, the citation is basically mentioned. Okay, so basically you are gonna make a list of the entire case, whatsoever cases you have referred, and you have mentioned in your memorial. You need to make the entire list of it, and you're gonna also mention about the citation of the same, right? So this is a list of cases which has been referred in this entire memorial. There are 26 cases. Yeah. Then comes is the list of abbreviations. Okay. Okay, we are very much well familiar with what abbreviation is all about, right? So whatever abbreviation you are using, short forms you are using in your memorial, you need to mention. You need to make the entire list. I guess you are able to see it over here, right? So you need to make the entire list of abbreviations, whatsoever abbreviation you are going to use in your entire memorial. Yeah. Moving ahead is statement of jurisdiction, one of the most important part. Okay, statement of jurisdiction is nothing but under statement of jurisdiction, you are basically going to mention about the article under which you are basically filing the case, right? So this particular case was filed in the High Court. So this was filed under Article 226 of the Constitution, right? And if it would have been filed under Supreme Court, it would be Article 32, right? So basically under which article you are filing the case, you need to mention about the article number, and you need to state the article. You can, I guess, clearly see that this particular jurisdiction is filed under Article 226 of the Constitution, and Article 226 has been also stated over here in the exact terminologies. So this is how you basically present the statement of jurisdiction. Then comes ahead is statement of facts. Okay, see, under statement of facts, the whatever your mood problem is, after understanding and reading the mood problem, you need to basically state down all the facts of the problem which were there, which was given to you. So you need to basically present all the facts of the case. So now there is one small tip: never ever exactly copy paste the facts of the case. Never do that. That's a small tip to you. You need to basically, you're not supposed to basically write the entire facts. There would be times wherein there would be a very huge problem of 4 to 5 pages or maybe more. So we are not gonna basically paste it, right? We are just gonna write a summary of the facts, right? You need to summarize the facts and you need to mention it over here, and you need to mention it in such a way that it is gonna basically favor you. If you are from the side of petitioner, try to present your facts in such a way that it is going to favor your petitioner side and vice versa for respondent, right? And there is a thing that the summary of facts should not exceed more than 2 pages, right? So you need to summarize it and you need to mention all your facts in a very clear manner and in such a way that it is basically favoring your side, right? It is supporting you. It will be quite good for you during your oral presentations out there, right? So you can see that this is a statement of facts. All the facts are basically mentioned for the case in a very brief manner. This basically particular case which is there, it is regarding the MTP Act, that is Medical Termination of Pregnancy Act 1971, and it is also regarding the Article 14 and Article 21 of the Constitution. Next comes is the statement of issues. So whatever your issues are, which you are going to deal with, you are going to basically just state out the issues. You're going to mention, okay, so and so are the issues, whether it's 2, 3, whatever the issues are, you're just going to state the issues out over here, right? So this is what the statement of issues is. You're just going to mention it over here. There are 4 issues which we can see regarding maintainability of writ petition, violation of Article 14 and 21 and not or not, and it is also regarding whether the right to reproduction is being basically upheld in its truest form and spirit or not, right? So whatever the issues are, you're just going to state the issues. Then comes a summary of arguments. Okay. See, summary of arguments is nothing, but it is whatever arguments you are going to basically present, you are going to present it in a short and summarized way. You are basically going to mention about the issue and the summary of the argument which you are going to present. Okay, and there is no need to put up any laws or anything over here. And it should also not exceed more than 2 pages. Within 2 pages, the summary of argument should be basically completed. So it is nothing but a summary of the arguments which you are going to present ahead, right? So no need to mention any sort of laws or cases over here. There is no sort of necessity, just a summary of the arguments. That's it. I guess you can see how it has been presented over here, right? Then moving ahead is arguments advance, the most important part of the entire memorial. So arguments advance is that part wherein you are going to mention about the arguments. On what sort of arguments, on what basis you are basically proving your point. So all your arguments or all your case law, that is precedents, whatsoever you're going to use, you're going to mention it over here, right? So you are basically going to give the reasoning why basically your client is right or why the court should give the judgment in favor of your client, right? So you're going to present all the arguments, all the case laws over here. That is one thing. So you could see that in a very detailed manner, all the arguments are present over here, and you can definitely mention the laws and everything over here, right? That is one thing. And always try to mention all your arguments in a very nice and peaceful, polite manner. And always write the conclusion. Always write the conclusion at the end, how it is basically, favoring you. Like you could see, just I will show you once. Like, uh, yeah, you could see. So basically, the first issue was regarding maintainability of the writ petition, right? So you could see the conclusion over here is given. The petition is maintainable under Article 226 of Constitution before the High Court, right? So whatever your conclusion is, do provide it. Whether it is maintainable, whether it is not maintainable, yes, no, whatever your thing is, always give a conclusion. Never end it without a conclusion. Always try to give a conclusion over here. And whenever you are presenting your arguments advanced, try to use IRAC method, right? Try to use IRAC method. IRAC method is nothing. IRAC method, IRAC. I for issue, R for rule, A for application, and C for conclusion. So whatever your issue is, mention about your issue, then apply the rule, and then you can write the conclusion. So
Can
basically,
you
you could
please
see
repeat it?
over
Ma'am, can you please repeat the terminology?
I for issue, R for rule, A for application, and C for conclusion.
Thank you, ma'am.
Yeah, most welcome. So you could see. So regard if there this is the first issue regarding writ petition, right? So we have mentioned about the issue, and we have then later on applied the rule that why the writ petition is maintainable, right? So we have basically applied the rule of locus standi. You can see this, that rule of locus standi states that unless an individual has been directly injured or is aggrieved by the act he is challenging, his action will not be upheld in the court, right? So basically the rule of locus standi has been basically applied over here. So that is how we do. We first mention the issue, then we basically apply the rule, and then at the end, we are going to basically mention about the conclusion. Whatever the conclusion is, whether we are in favor or whether we are not in favor, we are going to state about the conclusion. This is how you're going to individually address each and every issue, right? So you could see in the issue, we have even mentioned different cases, right? So I'm so sorry. We are having cases of UP versus MD Moot. I will show you. See, you could, yeah, you could see over here. UP versus MD Noot, state of UP versus MD Noot. We are having case of Himatlal versus state of UP, right? So these are few of the cases out over here. And if you would move ahead, you would be able to see more of the cases also. So that is one thing. Yeah, as I told you that while writing arguments advanced, we basically present it in a very detailed fashion, right? So we also at times write about the sections and all. So yeah, that's the thing. This is section 32B of MTP Act. Yeah. See, you could see the highlighted ones. We are having cases like Suchita Srivastava versus Chandigarh Administration, Justice K.S. Puttaswamy versus Union of India. Right. So there are different, a lot of n number of case laws which are present over here. Now there is a small tip for you. Whenever you are mentioning about any of the case law in your memorial, and you are saying that in so and so case, so and so judgment had been given by the bench, so try to put the exact wordings of the judge, what the exact wordings were of the judge, which the judge had said, rather than paraphrasing it, or you writing it in your own language. So try to use the exact wordings which the judge had said, which you could find from the judgment. Like you could see over here in Suchita Srivastava versus Chandigarh Administration, these are the exact wordings of the judge, which were basically said by him, right? So whenever you are mentioning the exact wordings of the judge, try to, make it distinguished by, maybe presenting it in an italics form or something such. Like over here, it is presented in an italics form, right? So try to always write the exact wordings, whatsoever was told by the judge, rather than paraphrasing it. This is a small tip which is going to help you out, definitely. So you could see over here. So that is one thing. Moreover, whenever you are writing arguments advanced, there is a need that you also need to mention the footnotes, right? You could see over here, footnotes over here, right? So in footnotes, you need to mention, right? So like Suchita Srivastava versus Chandigarh Administration, this is footnote number 15. You could see the citation which is given over here, right? So you need to even write the footnotes. The footnotes are nothing. Footnotes are basically the sources, right? Sources from where you have basically found the information, right? So now how to basically write a footnote, that is a different question altogether. So there is a Harvard Blue Book which is present. So according to the Harvard Blue Book, we basically write the footnotes. you could basically find each and every step in the Harvard View book, how to write a footnote in it, right? They're going because there is a different sort of format for writing a footnote. For books, it's different. For cases, it's different. For statutes, it's different, right? So, what is the format of writing a footnote? You can find it in Harvard View book. So, according to that, you need to write the footnotes also. And footnotes are very much necessary because if you're not going to write the footnote, your marks are definitely going to be deducted in a moot court. Yeah, so that is one thing. So these are basically arguments advanced and having all the case laws, issues, rule, application, conclusions, and footnotes. Very important. Okay, yeah. After argument, yeah, there is one more thing. At, after arguments advanced, just a sec, yeah. And the next thing is prayer, last thing of the memorial, prayer. So prayer is again nothing, it's a very simple thing. Prayer is like, what do you expect from the court, right? So you're going to mention about what do you expect from the court to give the judgment as, right? Whatever your view is, whatever you are expecting from the court, you need to mention. Like over here in this particular case, the petitioner wanted that the court should basically allow the writ petition to be maintainable. The court should basically, so I'm so sorry. Yeah, the court should basically clearly held that the rights are not violative and all. So whatever you are expecting from the court to give the judgment as, you need to mention about that in the prayer. So this is how you present the prayer. See, you can see there's a specific format again for the prayer to be written. So these are few statements you need to write, and this is what you expect from the court. So, I guess it's visible out there, right? So basically, this is how you need to basically present a memorial uh, for the moot court. And of course, there will be a detailed session altogether which will be happening for you guys, wherein you will be getting entire detailed explanation regarding the same, how a memorial is to be framed, and you will be guided for it, definitely. So yeah, so this was just a brief overview for you guys that how to basically, frame a memorial. Moving ahead, of course, just a second. After basically making the memorial, when you are going for the oral rounds, right? So there are certain etiquettes, there are certain manners, courtroom etiquettes which are to be followed, and there are certain do's and don'ts which we need to take care about, right? So whenever you are basically gonna present your argument, it is very much necessary that you should not rush with your argument. Never do that. Have a normal speed while giving your arguments. There should be clarity in your words, in your pronunciation, right? So just don't rush, and just don't in a way don't present your arguments in a very speedy fashion, right? And whatever your argument is, or whatever your idea is, try to put it in very straight words, in a very clear in a very clear way, right? And you would be able to present your ideas and views in a very clear way when you would be clear with your view, right? When beforehand you would be knowing, okay, this is what I want to say, and on this and so on, so reasoning, I'm gonna basically speak up my arguments, right? So you need to be clear. You need to be clear about the facts of your case. You need to be clear about your precedents which you have mentioned. You need to be clear about your arguments, right? So when you are confident about all your work which you have done, at that particular time you will be able to present your idea in a clear way. So ensure that you present your idea in a very correct manner, right? And that is one thing. And another thing is, always be a very good listener. While mooting, it's a very important skill which is required. Listening is the one of the most important skills out over there, right? So whosoever your opponent is, you need to basically listen to the arguments which they are speaking. right? Because when you are gonna listen it and understand it, on the basis of that only you will be able to oppose them later on and prove your point as yes, I am the right. My point is right, right? So until unless you don't listen what the other person is saying, you won't be able to prove your point. So in order to prove your point, you need to first listen what the other person is saying, right? So be a very good listener and always point out the weaknesses which are present in your opponent's argument, right? Next thing is always be very respectful, right? There are times wherein the environment in the court may get heated, right? But never disrespect your judge, never disrespect your opponents, right? If it happens that your opponent is, wrongly citing out something, right? You can express it in a very, polite and respectful manner altogether, right? So, and there might be times wherein, the judge might, the bench might ask you a lot of questions, right? Never get irritated, answer all your questions very calmly. And if it happens that, like hypothetically, if you're not knowing answer to any of your questions, right? You can say that you can say like counsel is not aware, or counsel will respond later if you do not know the answer, right? So be very respectful, be very calm, patient, right? Because it's all about confidence. I told you, because the more nervous you get, the more hyper you get, the more is the judge gonna roast you out, and it is gonna be difficult for you. So it's all about confidence, right? That is one thing. Next thing is body language, as I told you, right? That you should, never be nervous. Your body language matters a lot. Like, if you're nervous, you are, rubbing your hands or you're biting your nails. Yeah. So that is you should not do that at all, right? You should have a lot of confidence. You should believe in yourself. Yes, that whatever I'm saying, whatever I'm doing is right. So that is one thing, and always be very straightforward. Instead of confusing and guma ke bolna, right? It's better that be very straightforward, answer your question in a very right manner, in a very simple way. It's fine. No need to use a very high vocabulary or something. So it's fine if you are going very straightforward and directly in a simple terms. It's absolutely fine. That is one thing. So always take care of these few things out over there. And uh, before going to this, I would like to show you a small video, if possible. Just a second. Uh, just a second. Is my screen visible? And can anyone of you just confirm me if the audio is also audible or not, right?
Yeah, both are available.
Is the audio audible?
Yeah.
Okay, great. So yeah, just a second.
Sorry, ma'am, I am not able to hear.
Yeah, just a
Ma'am,
second.
it is not audible.
Okay, it's not audible. Okay, just give me 1 minute. Huh? I guess now it would be audible. Just give me a minute.
Mr. President, Your Excellencies, my name
Yes,
is
ma'am.
Christopher Bashara.
Yeah, it's audible. Yeah, there's a kind request to all of you. Please see this video very carefully. You would be able to see how this particular individual is basically addressing the bench and the confidence level that person is having. You could see how the body languages. Please kindly have a view to it in a very nice.
Mr. President, Your Excellencies, my name is Christopher Bashara and I appear for the applicant, the State of Sardinia, along with my co-agent, Glenn Kembry. I will be speaking first for 22 minutes. My co-agent will speak second for 20 minutes, and we reserve 3 minutes for rebuttal. Your Excellencies, the attack on the Backchar Valley Hospital was but one of 50 strikes in a Regalian campaign that violated Sardinia's territorial integrity and disregarded the minimum standards.
Mr. Bashara, could I ask you before you proceed any further? The claims that you're making with regard to the strikes, which claims are you making in terms of your own direct right, and which ones are you making in your indirect right, if at all, or are they both the same?
Mr. President, there is a direct injury to the state of Sardinia, namely the drone strikes occurring in Regalia's territory, foremost among which was the Backchar Valley Hospital strike. There are also drone strikes occurring in Regalia, and we note that separate bases of standing are pleaded in relation to each. With respect to the drone strikes in Regalia, we submit that Sardinia has standing on an erga omnes partes basis, which the respondent disputes at pages 1 and 19 of its written submissions. We submit...
Could I just... why erga omnes?
Mr. President, there is no identified Zetian on the compromis over whom diplomatic protection can be asserted in respect of these strikes, and Sardinia has to have recourse to the doctrine of erga omnes partes. We submit that standing on this basis derives from the 1949 Geneva Conventions and the 1966 International Covenant on Civil and Political Rights, to which both Sardinia and Regalia are states parties. We submit this court should find that these treaties confer a legal interest on all states parties in the compliance by other states parties with obligations under them. And this is supported by the text of the treaties. Indeed, Common Article 1 of the Geneva Conventions obligates all states to ensure respect for international humanitarian law. And as has been observed by Judge Simmer in his separate opinion in the 2005 armed activities case, one means of ensuring respect for humanitarian law is to institute proceedings in this court. Similarly, Article 2, Paragraph 1 of the Covenant has been interpreted by the Human Rights Committee in General Comment 31 of 2004 as conferring on all states parties, a legal interest in the compliance by other states parties with their covenant obligations. Now, the strongest argument the respondent has put against us in regard to standing is based on paragraph 91 of this court's judgment in the 1970 Barcelona traction case, in which this court stated, and I quote, "Human rights treaties do not confer on states the capacity to protect the victims of infringements of such rights." But in our submission, that statement goes to the question of jurisdiction, not standing. The court merely noted that many human rights treaties do not contain a compulsory interstate dispute resolution mechanism.
Could I interrupt you again? You're invoking the Covenant Committee as authority. What authority does that have? What binding character does it have for all these other states when they say every state has a right to bring this action?
Mr. President, the Human Rights Committee, its views should be ascribed great weight, as this court made clear in its 2010 Amadou Sadio Diallo decision. It is the chief interpretive body of the Covenant, and it may be considered a subsidiary source of law pursuant to Article 38(1)(d) of this court's statute. We submit that its statements are persuasive in this regard.
Yeah, would you please share with us some state practice on action started on the basis of erga omnes?
Your Excellency, we concede there is a paucity of state practice here. And that
paucity?
There is not much, Your Excellency.
Not much or none?
There is some, Your Excellency. We would note that Australia, in the nuclear tests case, did allege that there was an erga omnes obligation not to engage in nuclear testing. That is found in the written pleadings of the parties. The court has never applied the doctrine of erga omnes or erga omnes partes, but we submit that this is the appropriate case in which it should do so.
And you know how it ended, that case?
Yes, Your Excellency, we do. Ultimately, no decision needed to be made.
Yeah. So,
Computers and technology today hold the potential to
so that was one thing. I guess if you would have seen this video carefully, you would have been able to see that how confidently that person was able to argue the body language of that particular person, right? That individual, that how the body language was, right? So that is one thing that you need, and how most importantly, he was confident, he was humble, right? He was calm, right? Though the bench was asking a lot of questions out there, but that person was very calm and addressing to each and every question which whatsoever was asked to him, right? So that is one thing. So there are certain manners and etiquettes which you need to follow, like if just to name a few, like if there is the judge which is present, if it's a male, address him as your lordship, or if that it's a lady, it's a female, address her as your ladyship. And if there is a group of people out there, right, you address them as bench, right? So that is one thing, that how one thing, and you always need to have a very upright posture. You need to be humble. You need to always engage with the bench, and you should have that light and pleasant outlook all together, right? So always show respect towards them. Always show respect towards the judges, towards the opponents, to everyone, right? That is one thing. So these are certain basic etiquettes out there which you need to take care of. Now, of course, according to the location, according to the place, our attire changes, right? So whenever you are in a courtroom, there's a basic attire which you need to take care of. Like in a courtroom, always need to, wear a black suit or a black tie, white shirt, black formal shoes, right? And of course, a female at times even may wear a black or white suit or sari. And it is necessary that you should, not wear any sort of, ring or chain in your neck. Avoid, unnecessary accessories, whatever you are wearing. And, in a mood court, always try, uh, uh, try, it's not try, actually, it's a rule that, you should never, have that ID card or any object which will basically, reveal the identity of a university or college. It's a rule that you should never have that. If you would have seen the memorial over there, you would have seen there was a code which was given at the top, but there was, no sort of mention of the name of the college or university from where this entire memorial is, right? So in a moot court competition, you never reveal the identity of a college or university till end, right? So this is one thing. So this is the basic attire which you need to follow. Uh, so that was all from my side. So the floor is open if you have any sort of questions which you or query which you need to ask. Yeah. Anyone out
Ma'am,
there? Yeah.
hello, ma'am. Are we going to have a lecture on how to draft a memorial?
Yeah, you are gonna have different lectures ahead out there where you would be getting a detailed outlook for the same. I just gave you a brief overview, but you would definitely get a detailed outlook out there.
Okay, thank you, ma'am.
You're welcome.
Excuse me, ma'am.
Yeah.
Ma'am, that over the period of next 1 month, how many days, how many classes we will be having, and on what days? On what days?
Okay. Akshay, are you present over here in the meet? Just a second. Yeah. Akshay, am I audible to you?
Ma'am, Akshay is on mute. I think.
Yeah, I guess. Just a second. Just give me a minute.
Hello, ma'am.
Yeah,
Yeah.
Akshay.
Uh,
Akshay, I guess you will be able to address it better for the same.
uh, hello guys.
Yeah.
हाँ मेरी दूसरा एक वेबिनार चल रहा है अभी.
Okay.
हाँ, सो मैम कंक्लूजन कर दो इसका.
Okay, fine.
You can
हाँ
give that
और
detailed
आपका
background on.
आपका 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 कल एक ओरिएंटेशन सेशन होगा जो कि इसी टाइम पर होगा. ओके वो 2 hours का होगा.
Right. Okay. That's okay. Then we can discuss that tomorrow.
Okay.
So, Mr. Akshay, we will be having classes only on the weekends then? Or
नहीं
daily?
वीकेंड्स पे तो डेली बेसिस पर वीकेंड्स पे तो होंगी बट ऐसे वीक्स में भी होंगी जैसे जैसे हमारा पोर्शन कवर होता जाता है उस हिसाब से.
No, that is okay. That is okay, sir. My point is like, what will be the timing? Because we all have we all are working
Evening.
people. So looking into our schedule, we need to plan it out. So that's the reason we all are anxious to know, like, what would be the
all
time slot?
सेशंस इवनिंग में होंगे. all सेशन जितने भी होंगे उतने इवनिंग में.
Sir, evening, sir, that is one thing. I mean to know, like, what would be the time slot so that we can keep that slot ourselves free for this thing. Getting my point?
Just a sec.
कब लेना
Sorry to interrupt.
कब चाहिए फिर.
Sorry, Akshay.
कब लेना चाहिए मॉर्निंग टाइम 4 PM.
I think evening
Hello?
8 o'clock should be fine.
Yes,
Evening
yes.
on
Evening
weekend.
8 o'clock. Evening 8 o'clock on the working days. I think evening 8 o'clock would be much better rather than keeping it at 6. Right, Mr. Mahavir?
Yeah.
तो ओके मैम. ओके ग्रुप पे भी सारी चीजें डिस्कस करते हैं क्योंकि मेरा यहाँ पे वेबिनार चल रहा है पूरा का पूरा
Okay.
वो
Okay.
सिस्टम.
Akshay, you can carry on.
please.
We'll discuss tomorrow. We can discuss this tomorrow. Please carry on.
Okay.
And secondly, regarding the notes thing, what Muskan ma'am was sharing with us.
Ma'am, Smita ma'am.
Haji.
Actually, he has some other commitment. Now let him
Okay,
do that.
okay.
हेलो
Yeah,
मुस्कान
yeah.
मैम. मैम
Yes, sir.
मीटिंग रिकॉर्डिंग आप ये कर दो. रिकॉर्डिंग बंद कर दो.
Yeah, sure.
हाँ